All right, so what's new? I'm going to tell you what the recent laws you should know about, the recent cases you should know about, and the recent changes to the forms you should know about. Three things: laws, cases, forms. There's not a lot, and I think you'll be able to remember most of what I say. But let me start with the laws that you should know about, okay? First, let's start with the Bureau of Real Estate. Remember how it used to be the Department of Real Estate? Remember your whole life you called it the DRE, and now you're trying to get used to call it the BRE, right? How many of you still call it the DRE? Be honest. Well, guess what? It may go back to DRE. I swear to God. So all of you guys that just got used to doing BRE, you may go back to DRE. So we don't know for sure yet, but for now it's BRE. Okay. So what's the latest with the BRE? What are they really concerned? Well, first of all, there's two important new laws from the BRE you should aware about. First of all, who in this room has a broker's license? Okay, I'm talking to you. Every single one of you, unless you're over 70 and been in the business 30 years, every single one of you, the next time you do your 45 hours, you have to take a class on management and supervision. What if you're just a broker associate? You don't manage anybody. You still have to take this class. What if you're an agent, but you're a manager? I would recommend this class. You don't have to. What if you're an agent, but you don't manage anybody? There's no point in taking this class, okay? But you can if you want to. But anyway, there's a new class, all right? Second thing from the BRE, very important, you really need to know this, they're very serious about this, is the whole idea of teams. Okay, a lot of realtors, they don't just work by themselves, they work as part of a team, right? And then the problem with the BRE is these teams, the way they market themselves, they make it look like they are an independent company. In other words, let's say I was a realtor, right? And I live in Culver City. Let's say I work for Culver City Realty, right? So Gov Hutchinson, agent, Culver City Realty. Let's say I get a listing. So I put on the for sale sign, listed by Gov Hutchinson. Do I have to put the name of the company on that sign? Yes, you're right. But did you know that my name can be really big and their name can be really small? There's no requirement about the relative size. Plus, I don't have to put my BRE license number on the for sale sign. All right, I don't have to put the BRE license number. But let's say I'm a team. Let's say instead of working as an individual, I work as a team. You know, I got the Hutchinson team at Culver City Realty or Coldwell Banker. If I want to put that on a sign for sale listed by the Hutchinson team, the law says the team name can't be any bigger than the company name. So if it's just me, I could put my name big, the company name small. If I'm a team, it has to be the same size or the company bigger, right? So you have to keep track of the size of the team name and the other name if you're marketing as a team. The other thing is, if you want to be a team, you only have three choices to call yourself now: team, group, or associates. What if I want to call my team the Hutchinson Gang? I can't do it. I'm not allowed to do it. If you want to be a team, you have to use the word team, group, or associates. I think the real problem with BRE is some teams call themselves like Hutchinson Realty at Coldwell Banker. So it makes it look like they're an independent company, but they're not. So they don't want you using the word realty or some use the word brokerage. If you want to be a team, group, or associates. Well, what if I want to call my team something that doesn't even have my name on it? Like the Platinum Team. You know what I mean? The Platinum Team at Coldwell Banker. Can I do that? Well, that's a DBA. For that, you have to file for a fictitious business name. If you just want to call yourself the Hutchinson Team, Group, or Associates, it's not a DBA. You don't need to file anything. You just do it. And you have to make sure that the team name is no bigger than the company name, and you have to have your BRE number on the sign. And I forgot to mention, you have to have the broker's BRE number. So if you're just by yourself, you don't have to put any BRE license numbers on your marketing materials. If you're marketing as a team, Not only do you need the BRE license number of one of the team members, you need the BRE license number of the broker. You need 2 BRE numbers just because you chose to market as a team. All right, so let's say the platinum team. So I get a DBA. Then I use that. Well, what are the rules for that? Can that name be bigger than the company name? Here's the answer. It depends on who owns the DBA. If the broker allows the salesperson to own the DBA, then all that marketing has to follow the team rules. That name can't be any bigger than the company name. You have to put the real name and BRE license number of that person, and you must put the broker's BRE license number. But if you're marketing with a DBA that is owned by the broker, you don't have to worry about the size, and you don't have to put any BRE numbers. So let me summarize. There are 2 situations now when you have to worry about how big is the name, and you have to put the BRE license number there. Number 1, if you're marketing as a team. Number 2, if you're marketing using a DBA that is owned by the salesperson. And it's up to the broker whether they're going to allow you to own it or not. By the way, if the broker allows you to own it, that means you can take it with you to a different company. It's your DBA. But if it's owned by the broker, it belongs to the broker. If you change companies, you can't take the DBA with you. You see what I'm saying? All right, so one more thing. If you're a broker associate, you're always allowed to get your own DBA because you have a broker's license. And you can use that DBA in your marketing. But if your DBA you're using as a broker associate has the word team, group, or associates in it, you got to follow the team rules again. Isn't this complicated? I'm sure you're memorizing all of this, right? Well, number 1, there's a Q&A we have on our website on team names, explains all this. Number 2, apparently I'm being filmed here, so you're going to be able to, where's it going to be, on the website or something? YouTube? You can go to YouTube and watch me. If you don't hear everything I say today, okay? All right, so those are the big things from the BRE. You know what else the BRE is concerned about? They're concerned about that some realtors are doing property management, but they're not going through their brokerage. Remember, you need a license to do property management, and that means it's got to go through your broker. You can't just do it with a salesperson license, right? And the other thing that the BRE is very concerned about is they think a lot of companies, probably not good companies around here, but some companies are not supervised properly. They don't have brokers. The brokers are sort of just absentee brokers. It's just sort of rent a broker. You know what I mean? So what the BRE is doing, they're sometimes going to offices and just knocking on the door. And they walk in and say, "Is the broker here?" And the agent says, "No, she's not here." And then they say, "Do you know where she is?" And they say, "No, I don't know where she is." And they say, "Do you know who she is?" "No, I don't really know." This would be a red flag. This would be a looking, okay, maybe this is the type of company we're going to take a look at. It's not like the broker has to be there in the office, but you better be accessible, or at least have a manager that's either there or very accessible at all times. That's what they're looking for, okay? Because apparently they figured out that most of the violations are caused in companies that don't have good supervision. Agents need good supervision to follow the rules, okay? All right. So those are the laws from the BRE I want you to know about, and the things the BRE is concerned about. Next topic, other laws you should know about. There's a new law out there that doesn't directly affect you, but maybe indirectly affects you. There's a new type of way to transfer property on death. There's a new deed called the transfer on death deed. What I mean by that is, let's say you have a house, and you want, when you pass on, you want this house to go to your kid or something like that. You want the house to go directly to someone else. How do you do that? Well, today, up until this new form, you had 4 choices, right? You could have a will, put the house in the will. You could have a trust, put the house in the trust. You could be a joint tenant with someone. Or the extreme method, you could actually be married to someone and own the property as community property with right of survivorship. That's too extreme for me, but some people can do that. Okay. Now there's a 5th way to make sure your real estate goes to somebody else. It doesn't require a trust. It doesn't require a will. It doesn't require a marriage. It doesn't require an attorney. You just get this form called Transfer on Death Deed, You put your name as the owner, legal description, notarize it, record it, put the name of the beneficiary. When you pass on, the property goes to them. There's no probate, there's no will, there's no nothing. They just record a death certificate, and it's theirs. So it's out there. You can only do it for residential 1 to 4. It's revocable. You can change your mind once you do it. There's another form to just change your mind. As long as you're still alive, you can change your mind, right? Once you're dead, it's too late. And the other thing is, I mean, let's say you give someone this deed and then you sell the house. The sale automatically cancels this deed. So it's very revocable. Or if you're already married to someone with joint tenancy or community property, or you've already taken care of this property in a will or a trust, you can't do this. This is only if you haven't already made arrangements for this property. And even once you do it, you can easily change it by selling the house or putting it into a will or just revoking it. So I like to think of it as very revocable, but it is there and it does work and it's a new form and your clients may ask you about it. Okay? You with me on that?
Can you do that on community property?
No. Well, if you did it on community, remember if you own a community property, that means if you die, your spouse gets it automatically. So even if in other words, you can't supersede that. You'd have to change the ownership between you and your spouse to like tenants in common, and then you could put your share in a transfer of death deed. But if you're already married and you have joint tenancy or community property with right of survivorship, it's already taken care of. But I guess two spouses could each do one of these, and then, God forbid, they each die in a plane crash at the same time. Seriously does happen. Then the property would go according to the transfer of death deed. Yes?
How would that impact the property tax?
You know, just like any other transfer upon death. I mean, in other words, a parent-to-child transfer does not reassess. Spouse transfers does not reassess. But if it's someone you're not related to, yeah, it would probably cause a reassessment. But that would be true under a will or a trust or a sale anyway. So it's really no different. In other words, just like any other transfer as far as the rules are. By the way, what if you have 2 kids and you want this house to go to both of them? Well, you'd write both of their names on the transfer on death deed. What if you like one kid more than the other? This form will not work, okay? This form, they automatically get half. They get equal shares. If you want to favor one more than the other, you got to do a will. You put in the will. Johnny gets 2/3 because he was always nicer to me. Joey only gets 1/3. He was no good anyway. So there you go. But you couldn't do that on this form. You have to do it on a will. Okay? All right. Other laws you should know about. Do I have any landlords in the room? Property managers? The rest of you don't care, do you? So I'll do this quick. New things you should know about rentals. Number 1, all rental properties in California now have to have a smoke detector in every bedroom and the hallway. It used to be older homes that have never been renovated, you could get away with 1 smoke detector in the whole house. Now, I don't care how old the house, I don't care if it's 100 years old, whether it's been renovated or not, all rental properties have to have a smoke detector in every bedroom and the hallway. Meaning you got a 2-story house, 2 bedrooms on the 2nd floor, 2 bedrooms on the 1st floor, you need 6. Bedroom, bedroom, hallway, bedroom, bedroom, hallway. Okay? So that's all rental properties. Another thing with rental properties that's interesting, did you hear there's a new law, there's a new protected class? You know what a protected class is? You can't discriminate. So you know you can't discriminate based on race, religion, color of skin, country of birth, age, gender, disability, marital status, sexual orientation, whether or not people have children, or source of income. You know what that means? You can't refuse to rent to lawyers, unfortunately. Yeah. Because that would be discrimination based on source of income. But there's a new protected class. You ready for this? You're not going to believe this. The new protected class are criminals. Did you hear that? In other words, here's what I'm saying. Some landlords say, here's my policy. If you have a criminal record, I will not rent to you. You can't get away with that. You have to be more specific. For example, you could say, okay, if if you have a criminal record that was based on drugs or violence or theft, you could say yeah. But what if someone their only criminal record is they had a misdemeanor DUI 20 years ago? You can't just automatically say, no, they say it's too broad to have a policy that excludes everybody. So you can't just have a blanket. You can still do a criminal background check, but just don't have an automatic policy that no matter what, I don't rent to you with a criminal record. Be a little bit, nuanced on that. Be a little more specific than that, because HUD officially came out with this and said, you can't have a blanket rule like that. And the reason for that, they said that would have a disparate impact on certain groups who basically are overrepresented among the population that has criminal records. I'll give you another example. I mean, in other words, sometimes you have policies where you're not discriminating on purpose, but the result. Let's say you have a policy, I don't rent to people unless they have a rental history of at least 5 years. Well, that would be discriminating based on age, because younger people probably aren't going to have brand new, 20-year-old people probably don't have a 5-year rental history. So your policy, you weren't intending specifically to discriminate based on age, but the impact of your policy, right, would affect people based on their age. So that would be considered age discrimination, even though that wasn't specifically your purpose. So you always got to be careful about discrimination. It's not just you can't specifically discriminate, but if the impact of your policy would be discriminatory, it's also bad. Okay? All right. Another thing with rentals, listen to this. If you have a rental property and you have a private backyard, right, you now have an absolute right to have a clothesline. That's right, you heard me. A clothesline. You know what a clothesline is, right? You dry your clothes outside. So if the landlord says, oh no, you cannot have a clothesline, I don't want to see your clothes out in the backyard, get a dryer. You can't do that. You can't stop tenants from having a clothesline. If they have a backyard, you can say not in the front yard, not on the patio, not on the balcony, not on the deck. But if they have a backyard, you cannot stop them from drying their clothes outside. Maybe you should buy them a dryer. I mean, they could stop doing it, but anyway, okay? Remember last year I told you that there was a law that said if you have a backyard, you have the absolute right to grow fruits and vegetables in portable containers. Remember that? So what are they going to come up with next year? Last year it was growing fruits and vegetables. This year it's clotheslines. What's going to be next year? What's the next thing you can do in your backyard? I don't know what the law is going to be next year. They seem to let. By the way, what I just said also applies for homeowner associations. So a homeowner association cannot stop you from having a clothesline if you have a private backyard. Okay? I don't know why they came up with this law, but they did. Yes.
Talking about the smoke detector.
Yes.
Is that the landlord's responsibility to check the battery and replace the battery?
That's a very good question. His question is, when it comes to landlords and smoke detectors, is it your responsibility to check and make sure the battery's working? The answer is yes. You have to make periodic inspection of the property. The question is, what does periodic mean? Nobody knows. I think the consensus is at least once a year. There'll be a test case one day, I'm sure, that's going to define that. But you remember these new smoke detectors now have these 10-year batteries, non-replaceable, non-removable. But I still think you got to periodically go in and just make sure it's actually working, right? If you got the old kind where they replace them every year, you should go in there at least once a year to make sure that they replaced them. Can't you put in the lease, it's the tenant's responsibility to replace the battery? Yes, you can, but you still have to check yourself. Actually, this is good because this is the only real excuse you have to get into the property. You ever have a tenant you just don't trust? So you want to get in there sometimes just to see what mischief they're up to? So you knock on the door and say, I want to inspect the property, and the tenant says, no, everything's good. Go away. We don't want you here. You can't insist that you have the right to go in and inspect their property. But you can use the smoke detector as an excuse to get into the oh no, I just want to check the smoke detector. But you were just here last week. I know, I check it every week, you know? That's the diligent kind of landlord I am. So anyway, by the way, so let me make that clear again, because there was a recent case on that too. Listen to this case. There was a tenant on the property who was a bad person, and this, or just a crazy person, and this tenant is building explosives on their property. They're not a terrorist, they're just crazy. They're just building and burying them in the ground. So one day the gardener, this is actually true, the gardener was on the property, and he's walking around the backyard, and he steps on the explosive and it blows up. It doesn't kill him, but he gets hurt. So he sues not the tenant who blew him up, he sued the landlord who hired him and said, you should have been periodically inspecting this property to make sure your crazy tenant isn't burying bombs on the property. Well, for one thing, how would you know anyway that there was a bomb buried there unless you actually saw him doing it? But the court said something interesting. The court says you do not have an obligation as a landlord to periodically inspect your property. Even if it's a month-to-month tenancy, you have no obligation to go there unless you have reason to believe that there's a problem. But this landlord had no reason to believe that this tenant was crazy like this. So the court said, you're not liable, landlord. I mean, how would you know? You had no duty to inspect. You had no reason to think you should have inspected. So sorry, gardener. That's the way it goes. There's risk of being a gardener. So people are going to bury bombs in the backyard. You know, I mean, it happens. What can you do? Okay. So that was interesting, right? Interesting case. Speaking of rentals, let me tell you about another interesting case. You're not going to like this if you're a landlord. This was in Los Angeles, and there was a landlord and a tenant, and the lease agreement says tenant must get renter's insurance. You know what renter's insurance is? That's the insurance that tenant gets to protect their property if something happens. Like there's a flood or a fire, and it damages their personal property. This policy would protect their property. The reason the landlord wants you to get this is because if there's a problem with the personal property, they don't want the tenant coming after the landlord, said, it's your fault, the house had the flood, you should pay for my TV. They want you to have insurance to cover. Okay, so the lease said you have to have renter's insurance. Well, the tenant never got renter's insurance. For 15 years, they lived there, no renter's insurance. Finally, one day, the landlord says, I want to get rid of this tenant. What's my excuse going to be? I know what my excuse is. They never got renter's insurance. So the landlord gives the tenant a 3-day notice to correct the breach of the lease or quit. Remember, you can evict a tenant for 2 reasons. Number 1, they don't pay rent. Or number 2, they breach some other provision in the rental agreement. And by the way, I forgot to mention this was in a rent control area. So they couldn't just give them a 30-day notice or 60-day notice. They had to have a reason, right? So the landlord gives the tenant 3-day notice, get renter's insurance or else. But they gave him this notice on the Friday before a 3-day weekend. Very sneaky. The tenant could not get the insurance during those 3 days. They got it about a couple days later, but it took them 5 days to get the renter's insurance. Landlord says, too late. You had 3 days. You didn't do it. I'm doing an unlawful detainer. And they go in the unlawful detainer and they win, but then the tenant files an appeal. And on appeal, the tenant wins. The court says you can't evict this tenant. Why not? The court says California law says to evict a tenant for violating a term of the lease, it's got to be a material term. It's got to be something important. And the landlord knew this was the law in California, so that there was a provision in the lease that says tenant agrees that they can be evicted for any violation of the lease, whether it's material or not. Okay, so they put that in there. Pretty much all landlords do that, especially on commercial leases. The court said, interesting, the court said, well, first, California law says you can't evict if it's not a material breach. Number 2, this court says, this provision that you put in there saying that tenant agrees that they can be evicted for anything, even if it's not material, the court said that's not enforceable. That's against public policy. And then the court said, and not getting renter's insurance is not a material breach. So you can't evict the tenant. Plus, they know what else they said? You shouldn't have given them the notice on the Friday before a 3-day weekend. That's not fair. So what is this, the moral of this, what does this tell you as a landlord? Number one, you're wasting your time if you insist that they get renter's insurance, because if they don't get it, you can't do anything about it. Number two, every tenant now is going to, when you try to evict them, they're going to say, that's not a material breach. And maybe they'll win, maybe they won't. And the third thing is, don't even bother putting in a provision that says all breaches subject you to eviction, whether it's material or not. So this is not a great case for landlords, obviously. I mean, if they don't pay their rent, you can always evict them for that. And if you're not in a rent control area, you can always give someone, a 60-day, once the lease is over, you can give them a 60-day notice to leave. But I guess this is not good if you're in LA rent control or any place like that, okay? But I think it's more than that. I think you really can't insist on renter's insurance as a provision of the lease. You know what I mean? It's kind of crazy, but I would still put it in there myself. And I'd even pay for it for them if I really had to, because I think it's in the landlord's interest if the tenant has renter's insurance. Okay? One more on rentals. You ready for this? Let's say you're a landlord and the tenant has a problem with some type of pest. And I don't mean the mother-in-law. I mean termites or bed bugs or, God forbid, rodents of some kind, right? So they have a problem. Well, you have to fix it, right? Obviously, as a landlord, it's your job to get rid of the pests. So you could hire an exterminator or a pest control guy, but apparently some landlords have decided they can do this themselves. They don't need an exterminator, so they go on Amazon and they order the pesticide, and they go spray it themselves. Well, apparently some landlords don't know what they're doing, and they use too much. And they kill everybody. So it's not good. There's a new law that says if you want to do pesticides yourself, as opposed to hiring a professional, you have to provide a notice to the tenant in writing at least 24 hours before you start saying, this is the pesticide I'm going to use, this is how toxic it is, this is how much I'm going to use, this is when I'm going to start, this is when I'm going to finish. If you don't want to do all that hassle, just hire somebody. Then it's not your problem. Okay? Good question. I think I know what your question is, even though she just said Section 8. I think I'm going to read her mind, and her question is, do you have to rent to Section 8 tenants, right? The answer today is no. But guess what? I'm glad you asked that. There is a bill being proposed in Sacramento that would say all landlords must accept Section 8 tenants. C.A.R. is opposed to this law. We are fighting this law. I think hopefully we'll win, but there is a proposal. But right now, you don't have to rent to Section 8 tenants as a landlord if you don't want to. Okay? All right. Next topic, homeowner associations. I mentioned about the clotheslines in the backyard. You have the right to do that. Also, we are in a state of emergency. We are in a drought. So what that means is there's a law that says if you live in an HOA, the HOA cannot force you to water your lawn unless the HOA supplies recycled water for that purpose. If the HOA does not supply recycled water, if the HOA waters it themselves, that's fine. But if they require the owner to water your grass, they can't force you unless they make sure you have recycled water to do it. And number two, let's say you live in an HOA and you have a yard, and you say to yourself, I want to rip out that yard and put in artificial grass or rocks. And that won't use any water at all. And the HOA says, oh no, you can't do that. That violates our landscaping guidelines. You know what the law says now? Too bad for the landscaping guidelines. You have the right to rip out your grass, put in artificial turf, whether the HOA likes it or not. Well, what if you do that, and then 2 years from now, the drought is over, the emergency is over? Can the HOA come back and say, oh, put the grass back? No, they can't. Anything you do during the state of emergency that we are in is permanent, as far as you're concerned, okay? One more on HOAs. I can relate to this. If any of you sell condos, if you own a condo, like I do in Culver City, if you read your CC&R, let's say I have a balcony, well, let's say I read my CC&Rs. A lot of times, if you're in a condo and you have a balcony or you have a deck or you have a patio, you don't actually own it. If you look at your CC&Rs, it says the balcony is, you don't own it, it's owned by the association. It's called exclusive use common area. Meaning, and my balcony in Culver City says that. It says exclusive use common. You know what that means? It means I don't actually own that balcony, but I'm the only one who gets to use it. So if my neighbor knocks on the door and says, Gov, I want to use the balcony, I say, get out of here. You can't use my balcony. But I don't actually own it. So what does that mean? Well, what if the balcony has a problem? What if there's a crack or something? Who has to fix it? Aha. Well, so I look at my CC&Rs. The CC&Rs say I have to fix it. But guess what? There's a law now that says they have to fix it. Doesn't matter what my CC&Rs say. By law, they have to fix exclusive use common area. Okay? All right. Next topic. If any of you guys have employees, some companies, I know you have people, staff working for you who aren't agents, or maybe some of you agents might have an assistant working for you who's an employee. Remember two things. We have mandatory sick time in California now. You got to keep track of anyone who works for you at least 30 days in a year. You have to keep track of their hours. And every 30 hours they work, they've accrued 1 hour of sick time. And you know, you can limit them to a total of 24 hours of sick time, but once they reach that limit, if they take a sick day, then you got to start calculating it again. But you can avoid the hassle of that, of keeping track of it, if you front load and give them all the sick time at the beginning of the year. For example, you can give them you can tell them in January, you have 3 days of sick time this year, which means they could call out sick the first 3 days of January and then quit on the 4th day. And you owe them 3 days pay. But at least you don't have to keep track of anything. You know, so my employer gave me 6 sick days on January 1st. You know who my employer is? You guys. I want to thank every realtor in this room for giving me twice as many sick days as you had to. Thank you for that. Don't worry, I'm not going to use them. I don't know, not me, but I haven't taken a sick day since 2012, so don't worry about it. I'm good. I'm not going to use them. What if your employee accumulates a lot of sick days and then they leave? Do you have to pay them? No, you don't. You don't have to pay them. Another thing is, did you hear minimum wage is going up? It's going to go up steadily the next few years. Right now it's $10 an hour. January 1st, $10.50. A year after that, $11. A year after that, $12. A year after that, $13. A year after that, $14. A year after that, $15. That's if you have 25 or more employees. What if you have less than 25? Well, everything I said is backed up a year. So it won't go to $10.50 until January 1st, 2018. And it won't go to $11 till January 1st, a year later. But still, eventually, it's all going to go up. Okay? Last thing I want to know about, are there any short sales going on in the San Gabriel Valley? Good. If they do come back, though, I have good news for you, is that they reinstated that tax break. Remember what a short sale is? The lender doesn't get paid all the money they're owed. Remember the IRS says that means you got to pay income tax on the debt forgiveness. But then there was a law that says you don't have to pay income tax on debt forgiveness on a purchase money loan. Remember that law expired? Well, it was reinstated retroactively. So if any of your clients did a short sale last year, and if they paid any federal income tax, they probably can get a refund. And if they do a short sale this year, as long as the original loan was a purchase money loan, they're okay. All right? That is about it for the new laws I want you to talk about. Next topic, yeah. Of course, only to the end of this year. Every year we have to fight this. Every year we have to fight to extend it another year. So the way it stands right now is you don't have to close escrow by the end of this year. You have to sign the contract by the end of this year to avoid the income tax on a short sale. You're okay on a refi. You're even okay on a refi if you took money out. But if you refied and took money out for something other than putting it back on the property, you'll probably have a partial tax consequence, okay? Not a complete one. Be careful about don't give tax advice to your clients, but that's an issue to know. Yeah.
Regarding the pet control, the cockroaches, tenants have so many cockroaches even fly around.
They're flying around. That's not a good tenant. Why don't you just evict that tenant? Remember, if it's not rent control, you don't need a reason to evict them. Right? I mean, once the lease is over and they become month to month, you don't need a reason. Just get rid of them. If you're on a lease, you could probably even evict them early because tenants are responsible to have basic housekeeping. I mean, a tenant can't just not take care of their place. That's grounds to evict. But at the end of on a month to month, you don't even need a reason, right? Okay? All right, next topic, other cases. I told you about that one case about the pet insurance case. Other interesting cases. Imagine this happening to you. Have you ever been the buyer's agent and you got a transfer disclosure statement from the listing agent and the seller didn't answer all the questions? Have you ever seen that? Remember there are 20 questions? Okay. Did you know that the transfer disclosure statement gives the buyer a 5-day right of rescission? In other words, if I give you the TDS, if I give it to you in person, you have 3 days. If I mail it to you or email it, you have 5 days to walk away from the contract. That's whether or not you've removed your contingencies, which is why you always give the transfer disclosure statement to the buyer as soon as you can, so you get those 5 days where they have the right to cancel out of the way. So this actually happened in this case. The seller filled out the TDS, but they didn't answer every question. But they signed it. The listing agent signed it. They gave it to the buyer. Buyer signed it. Yes, you gave me the TDS. This is first week of the escrow. Then the buyer goes through the deal. They remove all their contingencies. They're getting ready to close. 2 days before closing, the buyer says to the seller, you know what? I changed my mind. I don't want to buy your house. Give me back my $50,000 deposit. It was expensive property. Seller says, I don't have to give you back your money. You do not have the right to cancel. You've removed all your contingencies, and I gave you the disclosure a long time ago, so you don't have any right of rescission. If you cancel, I'm liquidated damages. I'm keeping your deposit. Buyer says, oh, no, I still have a right of rescission based on the TDS. Seller says, you signed saying you received the TDS. The buyer says, yes, I signed acknowledging I received an incomplete TDS. Your seller did not answer every question. I never got a TDS. I still have a right of rescission, which I am exercising. Give me back my money. Seller says no. Buyer sues. Buyer wins. Make your seller answer all the questions on the TDS. According to this one judge, this case was not appealed. It's not an appellate case. I can't say it's California law. But if this one judge said that, I bet another judge would say the same thing. So you got the story there, right? Here's another interesting case regarding the TDS. You're the listing agent, right? And your seller fills out the TDS. But your seller is not truthful. Your seller lies. Can you imagine that? One of your own clients not telling the truth. Okay. I know it's hard to believe, but they did that. You didn't know that. The listing agent didn't know it wasn't truthful, but it wasn't. It doesn't even matter what it was. Okay. So they fill it out, give it to the buyer. Buyer buys the house, closes escrow. After they move in a couple months later, the buyer discovers the problem that the seller lied about. So the buyer's mad, so the buyer sues. But instead of suing the lying seller, they sued the listing agent. Of course. Why would they sue the listing? What's the argument? And the plaintiff's argument was, well, it's the listing agent's responsibility to make sure that everything the seller says is true. Hold on. The realtor won the case. Aren't you glad? Isn't that good news? I finally give you some good news. The court says something good. So that's good news. But don't get completely excited about that because I've seen other cases that say, okay, well, it's not your job to investigate and verify everything the seller says, but you still have to look at what your seller says, and if they said something that's obviously wrong, that you don't have to investigate. And let's say that they say on the TDS, the house has a swimming pool. And you know the house does not have a swimming pool. You're supposed to say to your seller, don't check the box, it's got a swimming, change that, it doesn't have a swimming pool. You know what I mean? So it's sort of a fine line there. You got to look at what they wrote, correct obvious mistakes, like they say there's no HOA, you know there's an HOA. But you don't have to go to the next step and independently investigate the stuff that you'd have no idea whether it's true or not. Okay? So you got to walk that fine line.
In my experience, though, in this situation where there's a lawsuit like that, the attorney will tell them to name every
Of course. Oh, that goes without saying.
agent, so even if
But at least you're going to win the case. Right.
the seller's still going to be
Oh, you're going to get... Seller and listing agent are always going to be sued. That's true. Yeah, right. That's another good thing. Point out to your seller that they should be honest. But what if, for example, the house doesn't have a swimming pool and your seller checks the box, it's got a swimming pool. So you go to your seller and say, you know, it doesn't have a swimming pool. Change that. And the seller says, I'm not changing it. Now what do you do? Well, on your part of the TDS, you have to write something like, my client's an idiot. I don't know why they insist on telling you this, but I am hereby telling you there's no swimming pool. You know, I mean, you almost have to go that far. Or just quit the transaction if your client's that crazy and dishonest. Okay? All right. One more case that you'll find interesting. So you got these cases. One is don't demand pet insurance. Fill out the TDS completely. And you don't have to verify the TDS, but you have to still look at it. Here's an interesting case. This is a true story. You got two realtors working together in Los Angeles at a Keller Williams office. And they decide, they're good friends, they have the same sort of approach, and they decide, let's be partners. So they agreed to be partners. Not every deal. Some they do their own transaction, but some transactions they did together as partners. They weren't related, they just partners. You've seen this sometimes. So they did some deals, they're doing fine, and then one of them leaves Keller Williams and goes to a different company, right? And this other company happened to be in Beverly Hills. At his new company, this realtor finds a really good buyer and represents this buyer on a purchase of a $15 million Beverly Hills house. And it closes. And he gets paid a check of $210,000. Best day of his life. Until his friend back at Keller Williams called him up and said, way to go, buddy. Where's my half? And he says, what are you talking about? I mean, yeah, back at Keller Williams, we were partners sometimes. But even if we were partners all the time, I don't work there anymore. Obviously, we're not partners anymore. And the guy back at Keller Williams says, I don't think it's obvious. Why can't we be partners at different companies? You owe me $105,000. So the other guy says, drop dead. But the guy back at Keller Williams sues the agent for $105,000. Okay, so they go to trial, and the trial judge says, you can't sue this guy. Number one, commissions go through the broker. So if you're going to sue anybody, you got to sue a broker. In other words, if someone owes you money in real estate, it's either your broker or your client. Another agent can't owe you money. And number two, the trial judge points out, plus, obviously, two agents in the same company who aren't in the same company, how can they be partners? But then the guy at Keller Williams filed an appeal, and he won. The Court of Appeals said, number one, agents can sue agents. Because this is not a commission case. This is just a suit to enforce a commission sharing agreement. So you're not really suing him for a commission. You're suing him for a share of a commission that had already been agreed to, and the fact that you don't work in the same company, so what? Who says you can't be partners in different companies? So what's the moral of this story? The next time you're out drinking with your realtor friends, and you say to your friend, you know, I think we'd be good partners together. Let's do some deals together. You might have just committed yourself to hundreds of thousands of dollars. Oh, did I mention a commission sharing agreement could be verbal? How do you prove that? Of course, you have to have witnesses, but in this case, it was in writing. They did have a written partnership agreement. But the court is pretty clear that whether they had a written agreement or not, commission sharing agreements can be enforceable. Just be careful about that when you're dealing with your other agents. By the way, I've always said this about referral fees. If you verbally promise another realtor a referral fee, that's binding. But you know what you've done when you verbally promise someone a referral fee? You've obligated your broker to pay their broker, because commissions and referral fees have to go through the brokers. But what's interesting about this case is the court said, this is not really a commission case, this is a commission sharing agreement, so it doesn't have to go through the brokers.